other people, on behalf of Mr. Jeffrey Williams, Mr. Adams and I would like the court to reconsider its denial on two previous occasions of bail. We filed this motion on April 24th, 2023, and we allege that Mr. Williams has been in custody since May 9, 2022. It's the date of his arrest. As the court previously heard, and if you need me to go over it, I will, but I'm assuming that this honorable court remembers the previous bond hearings and all the witnesses and exhibits that we placed before the court. I do, sir. I assume you did. Mr. Williams, as you know, you remember, did not flee when law enforcement officers came to his home on May 9th, 2022. He came out of his house, called me, actually, and then came out of his house and was not in any way, anything compliant. It's now been more than 14 months so far. As the court may know and remember, the only potential nutritional foods consumed by Mr. Williams since May 9, 2022 include carrots, rice, lettuce, beans, and hot dogs. He mostly consumes products which have absolutely no nutritional benefits, which are M&M's, chips, other processed or artificial, bagged chemical substances. The lights, as the court may remember, in the small, isolated, solitary cell that Mr. Williams is housed in an off-site county. The lights are always on. They are brighter than the lights in this courtroom. So sleeping with bright lights in his face all the time, if he can get to sleep. And that is a form of torture which is not compatible with necessary restoration, sleep, restorative sleep required for Mr. Williams, who is a person on trial and needs to assist his counsel. Your Honor, this lifestyle for the past 14 plus months has caused physical harm to Mr. Williams. As the court recalls, he was taken to the hospital. If the court does not know, Mr. Williams gave me permission, it is for his kidneys. Mr. Williams was raised in total poverty. He is used to not seeking medical help because he could not afford saying when he was injured or hurt. But he comes in this courtroom every day, writhing from pain from his kidneys. The kidneys removes the waste and extra water from the blood, evacuates through the body, through urine to maintain balances of the body's substantive fluids, to keep proper balance and levels of potassium, calcium, and sodium. The diet consumed by Mr. Williams endangers his health. Pre-trial incarceration, Your Honor, is not supposed to damage a person's mind, spirit, or body. It's not for punishment. And this physical incarceration for such a long period of time, and the trial is estimated to last 6 to 9 months, and that's a considerable amount of time. The court has always said, I will put you on trial right away. I'm very aware that I denied bond to your client, and we appreciate that. We filed demand for speedy trial statutorily and constitutionally. But it is still a long time. As the court may notice, takes note of Mr. Williams, he has gained tremendous weight. If he's weighed now, compared to the time he weighed on May 9th, you will see how much weight he has gained. He does not fit into his clothing anymore. He has no new clothing, and this is a problem caused by the kidneys and the lack of nutrition and exercise. Your Honor, the support for the community is still here with Mr. Williams. It remains here, as I previously showed this honorable court, to a packed courtroom. There are people who have not wavered at all. His family is all from this area. They love him, devoted to him. I speak with them weekly, if not more. His friends have stayed with him. Co-workers of Mr. Williams in the music industry. One is the gentleman who is on your screen in courtroom 8H, as in happy. His name is Jeff, which is Geoff, Ogunlesi, Ogunlesi. He has flown across our country to be here today when he found out that this honorable court set the hearing on Tuesday. He is in, if you need him, he is in court 8H, and he will speak to the court if needed. There are professionals of the highest, officers of publicly traded company, the record label, that are on your Zoom, Mr. Kevin Liles, Liles, and he authorized me to tell you that he again in total his previous sworn live testimony before this honorable court, and he stands by it with all of his power and might, and is willing to answer any of your questions that you would have of the prosecution for bond for Mr. Williams. Within this past month, Your Honor, Mr. Williams released a record. It was...
I'm going to object to this proffer opening or this portion of it as irrelevant to a bond hearing.
I can answer that if I need to. It goes to his employment and his steadiness of employment in the industry and in this trial at this time. He is still maintained total employment and he's still active.
Okay, all right, I'll allow it.
He is a number, that record, Your Honor, became the number one rap record in
the, objection, Your Honor, I may finish my objection to as to
What's the basis? Relevance? I'm going to overrule the objection this time. All right.
Is the number one rap record.
Let's move on, Mr. Steele. I understand it. You've convinced me that he's employable. So,
Well, I think the court should know it's also number two record in any field. And I think that that's important for the court to realize there's no risk of violating condition of bond. This gentleman is an accomplished superstar in music, and I think that should weigh heavily that he would not jeopardize that by violating any condition of bond. Your Honor, America's justice system is built on the presumption that bail should be granted if there are any conditions that can be factored to ensure that the community is safe, the person does not pose a danger to the community, witnesses will not be intimidated, there will be no obstruction of justice, the person will not, in this case Mr. Williams, will not commit a felony or any crime, it says felony, but any crime while out on bond, and that Mr. Williams will appear in court. Because if we do it the other way, and maintain people and house people and warehouse them as Mr. Williams has been, then the presumption of innocence, which is our entire standard in Georgia, is gone because he's being presumed to be guilty. Your Honor, Georgia, unlike some states, for purposes of pretrial bond, the presumption of innocence remains with Mr. Williams accused of any offense, even a capital offense, which Mr. Williams is not charged with a capital offense, from arrest and even during trial. That's Vanderford, V-A-N-D-R-F-O-R-D, versus Brand, B-R-A-N-D. It's 126 Georgia, 67-7-1906. That means, Your Honor, that prior to trial, this honorable court must view Mr. Williams to be innocent.
I do. Look, I understand that you're trying to meet your burden in the sense of for the four factors under law. So I'm gonna assume that I take into account the prior testimony that you've given in this particular case. Is there anything that you want other than the updated issues as to his record release recently and employability? Is there anything else you want to augment that with?
Yes.
And then I'll let the state respond and present anything they may have to the contrary.
Yes. Okay. I have seen, and I've been here for every bond hearing except one, Mr. Miles Farley. I was not present for that. And I've seen this honorable court deny every person bond who's in this indictment. But then, 7 months later approximately, I saw the state who had called all these people that they are a danger to community. They cannot fashion this honorable court cannot fashion any conditions of bond that would permit bond to be granted. And then 7 months later, the prosecution for 8 co-indictees offered and this court accepted negotiated pleas of time served. I can't wrap that around my mind.
What does that have to do with your case and your bond? I mean, each individual defendant is on his or her, in this case, their own merit. So, why does that have anything to do with you?
Because I don't believe that the
Your client, I should say.
I don't, it's fine to say me, but I don't believe that the proffers you're getting from the state are accurate. They have been proven to be inaccurate. I heard
Unfortunately, that's the way the law goes at this point in time, and our legislature hasn't addressed that. I mean, you've asked me to take a look at that. It's a different standard, pre-trial as opposed to in trial. So, I mean, I understand that. I know you'll probably review that at some point in time, but at this point, I'm stuck with what I'm stuck with in terms of the legal posture of what the Constitution and the case law allows me to do.
there is no case that says that there's a difference between pre-trial and in-trial. That is not accurate.
In terms of the standard for motions and requirement for witnesses and live witnesses, should there be?
I misunderstood. I thought you were talking about bond law.
No.
Okay,
No, sir.
So you did grant bond. I was not present. But you did grant bond for Mr. Miles Farley, and there has to be a way that
On the individual circumstances of Mr. Farley, Mr. Williams I have to judge it on his particular circumstances.
I'm judging Mr. Williams. I think Mr. Williams is more than bond eligible. Your Honor, we still have the same officers willing to supervise and surround a home that will have no electronics and no visitors. There will be no computer, no cell phone, and law enforcement officers outside of the house. We will pay for transportation to and from the courthouse. Otherwise, with an ankle monitor on his person, he does not leave that home. Mr. Adams and I and our other co-workers would request to meet with Mr. Williams inside that home on weekends and at nights. But other than us, nobody comes in. We can leave our electronics outside and bring paper copies because that's what I do at the outside jail anyway with Mr. Williams. Now, sometimes they do let me come in with my iPad to share discovery with Mr. Williams. I have to ask special permission, and I can do that through the court. But, Your Honor, that is a factor that should be considered by this honorable court, that Mr. Williams can live at a location that can be vetted by this honorable court and law enforcement and the district attorney's office. I've gone further. Not only with local police officers, if you don't like local police officers, I'm not saying anything wrong, but for whatever reason, that is not sufficient. There is a former Secret Service agent. There is a former U.S. Marshal that would take the responsibility of securing and transporting Mr. Williams in a home by himself and following every condition of bond, which we would ask for at this point. No visitors except legal, and not to leave the house except if you had to go to a hospital and on an ankle monitor. Your Honor, liberty is the norm in our community, and this custodial detention prior to trial, when there are conditions that can be fashioned, is against our law. I will answer any of your questions. Mr. Ogalesi will answer your questions, but he is Mr. Williams' manager. He will answer any questions, but he is behind Mr. Williams 100%, and Mr. Kevin Lyles is with the record label, and he also is with Mr. Williams, and I said I incorporate his prior testimony. Your Honor, I want to answer any of your questions. I want to thank you always, but this is a big case with a lot of discovery. We got discovery yesterday evening. I go through with Mr. Williams. I'm with him every day. I'm in court with him. I'm on a Zoom call with him, privileged Zoom call at the jail. I'm with him at the jail. It is a lot better for us if he can stay awake, if he can participate and assist. And there are conditions that we have because he has the resources. That doesn't mean a resource to flee like you heard he could rent a plane. He's not doing that. He has too much to lose and he's too recognizable. Thank you, sir.
Okay. Thank you, Mr. Steele. All right. Ms. Lover, Ms. Hilton, ladies.
Thank you, Your Honor. Your Honor, to begin with, I noticed that Mr. Mr. Still referenced this status, the state that we're in as pre-trial. I noticed that and noted it because I wanted to make certain that the record is clear that we are currently in trial. We are not at a pre-trial status or state. Mr. Steele referenced the fact that he has demanded a constitutional and a statutory speedy trial. And Mr. Steele also referenced the fact that the court promised or guaranteed that his client would receive one, and in fact, the court has upheld that promise, and we are in trial. The statutes in the case law that reference bail and bond also use pretrial release interchangeably with bail and bond. And so I just wanted to point out that we are currently in trial. Also, Your Honor, since the time that this court first found that the defendant poses a risk of committing additional felonies and poses a flight risk, there has been no change in circumstances beyond what Mr. Steele has described as the defendant's discomfort, his dissatisfaction with the food that he is given, his choice to only eat certain foods that are provided, and that's it. Using the rationale that Mr. Steele employs, it's tantamount to being unconstitutional to confine anyone, given the description that he has made of his client's circumstances and his assertion that every person should have the right to be free from those type of circumstances. I want the court to take note of the fact that the legislature, in enacting the statute for which Mr. Williams is charged, said that they wanted to make certain that the community is free of intimidation and threats caused by criminal street gangs, understanding that the state has the burden of proving all of the charges alleged in the indictment at trial. We are at a position, however, where we can point to circumstances that reflect that the defendant poses a significant risk of committing additional felonies. These acts that the defendant has committed go very far back. They include acts of intimidation during the time that his brother, Your Honor, I am proffering as an officer of the court.
Yeah, let her finish, please, Mr.
I apologize for your objection.
What was the basis?
It goes against the law for presumption of innocence. This is the charges in the indictment which the court has to presume innocent. It's an improper argument.
I believe it's just her proper. I understand the legal requirement, and your client is presumed innocent. But I think Ms. Love is proffering how Mr. Williams is or continues to be a danger to the community.
Thank you, Your Honor.
Using the irrelevant information is the indictment. That's what Ms. Love is referring to.
It is not.
I don't think she's referring to the indictment. I think she's referring to acts that she claims will support the issues of bond. Bond is different from trial on the merits.
I understand, but I listened intently, and this is the indictment. That's what Ms. Love just stated.
It's the charging document, but I understand, Mr. Steele, it's different. The state has the burden. Bond is different than proof at trial. I understand that. Do you have any further objections, sir?
401, Reverend 402, relevance.
I'm going to overrule the objection. Go ahead, madam.
Thank you, Judge. The defendant, as far back as the time when his brother, Mr. Greer, who was before the court earlier this year, was initially set to be on trial, was one of the witnesses, and in fact, a person very close to the defendant, called the police and indicated that the defendant had messaged her, snitch hoes get murked, them and their kids.
Mr. Williams you're referring to?
It is.
No, I did not get that.
Snitch hoes get what?
Murked, M-U-R-K-E-D.
Get murked and what else?
Murked them and their kids.
Okay, I got it.
Your Honor, in 2015, Mr. Steele may present the objection that this is part of the indictment, but I can play the actual video where the defendant proclaims, so people lied to their mama, lied to their sister, lied to their children, and then want to get in court and tell the God's honest truth. You need to be killed, bro. That's from me and YSL. Those were his words. Judge, the intimidation factor and the risk of committing additional felonies that the defendant presents is not small. I know that you have heard proffers for prior prosecutors and you've heard evidence in previous bail hearings regarding witnesses' representations as it relates to this defendant. I can state, having experienced them myself, that the witnesses have expressed extreme reluctance. One said, with fear in his voice, he's different now. He's not the same. He moves like a man with millions of dollars behind his name. And in fact, the circumstances presented to you by Mr. Steele in both this hearing and in previous hearings reflect a similar sentiment. He moves like a man with $1 million behind his name. His hands won't get dirty, but people will enact his wishes. Since the time that we have been in this trial, we have seen it was captured on surveillance footage from inside this courtroom. One defendant who was on trial with this defendant bring to Mr. Williams Percocet in open court. Since the time that this trial has begun, we have had no less than 20 incidents, involving various crimes from drugs, shanks, and attacks being committed while the people who have been charged in this indictment are in fact confined. We have recordings of persons who are charged with Mr. Williams reaching out to other parties on the indictment, requesting permission from Mr. Williams to do harm to an opposition member who is in jail with the calling party. We have calls that are recorded of persons reaching out to Mr. Williams and conveying Mr. Williams' phone number and telling the called party, save this number under my name just in case, the police get the phone. Everyone inside and who is associated with YSL knows who they need to keep the hands clean for, because Mr. Williams is the money that attracts the action and the willingness to act. When the shooting occurred that is referenced in the indictment of the bus for which Jimmy Winfrey was later convicted, it occurred at the same time that Mr. Williams was on stage in the other artist's hometown getting a not so receptive reaction from the audience. Your Honor, in 2015, of course, the court is aware that the state alleges that Mr. Donovan Thomas was killed as a result of conflict with opposition members, and that the vehicle, we do and can state that witnesses state that the vehicle that was used was one rented by Mr. Williams. We have proffers from persons who have pled, who have said that that Mr. Williams then gave everyone money to get out of town that same night. In 2015 rather, understanding that this particular evidence won't be used at trial, much like hearsay is inadmissible, but in 2015, Mr. Williams is found with guns and drugs inside his home, one of them purchased through a straw purchase. You would think after being arrested for that in 2022, he wouldn't have a cache of drugs inside his kitchen, a whole drug store, in fact, inside his kitchen. But not only does he have that, he has guns that have been modified with switches to make them automatic and other firearms inside his home. The person who is listed on the indictment, Mr. Jamari Holmes, as a victim of murder and for which Rodelius Ryan and Damone Blaylock were convicted, those persons, after the killing, placed on social media something akin to slime over hose. In 2022, after two persons who are friends with this defendant are gunned down and killed, the same day or a day after, a picture is posted with Mr. Chamel drinks by Kelvin Watts. And the picture has a zipper face over it and two black shells underneath. A day or two later, Chamel drinks is gunned down. The defendant is charged with being a leader of YSL. The legislature made a point of carving out a separate and additional statute for one who is the leader. Because though the leader may be the one that associates want to keep the hands clean for, they are the ones with the most influence. Jurors have come in and expressed or have shown themselves to be unwilling to be truthful out of fear. Witnesses are afraid and intimidated.
I don't know about the jurors, but the witnesses, only ones I can listen to in terms of proper what you're telling me at this point in time that you've actually interviewed. So
yes.
I'll make that clear.
Thank you.
All right.
Your Honor, even after, again, being arrested and having been found with drugs and guns in his homes, the defendant in DeKalb County is stopped and found with drugs and guns. I believe that at a previous bond hearing, prior FTA was referenced by the prosecution. Mr. Steele's assertions regarding the nutritional content of the food that the defendant has chosen to consume while he has been confined does not rise to the level of warranting additional circumstances that merit the defendant's release during trial. We would ask that the court find that based on the actions of the defendant, he presents a risk of committing additional felonies and that he poses a risk of intimidating or threatening witnesses. Your Honor, incidents prior to the ones charged in this indictment involve the defendant's presence at other violent felonies, his participation in them, and witnesses' statements that Thug made me do it, I knew I should have followed my mind and ran with him. Other people who are named in the indictment were charged and later convicted, but the defendant is the one who managed to avoid being accountable or held accountable for those actions.
Ms. Love, can I ask you a couple of clarifications? When did the
snitch hoes get murked?
Snitch hoes get murked, and then they and their kids get.
That was in 2010 at the time of Quintavious Greer's trial
Okay.
and the incidents where calls were made.
Is that more recently?
Yes, it
When was
is.
that?
Those were made in 2021.
Any calls or any other things after the commencement of this particular trial? Anything after December of 2022? Or into 2023?
As we are still reviewing the calls that we have received, I've not come upon ones from 2023. I can only point with respect to things that have been observed by officers and members of the state's staff, the drug transactions that have occurred.
Do you have interviews with more recently? Some of the things you told me, are those based upon witness interviews that you have indicated that have been held sometime by your office, sometime during 2022?
Yes.
Or and 2023?
Yes.
Okay. All right, madam, anything else?
Not at this time, Your Honor.
Okay.
Thank you.
All right. Mr. Steele, anything else, sir?
Your Honor, I reject the proffer. I would ask you to order the prosecution to hand to the court and to Mr. Williams' counsel. Snitch hoes get murked, then their kids in 2010. That did not happen.
She's an officer of the court,
And
and
so am I.
okay, and
And you should,
I believe the law, and Mr. Samuels attempted to, when he was involved in this case, to have me do that, and the law doesn't require me to do that.
Your Honor, if you rely on that, you should know what you're relying on. That does not exist. Calls made in 2021, it's a wiretap that they may be referring to. Mr. Williams is not on a wiretap. I've listened to every call.
Okay, well, I'm going to give that less weight than I would the conversations that Ms. Love has had with recent witnesses in 22 and 23.
Let me give you something out of discovery. Mr. Eppinger's mother said that Jeff Williams ruined her son's life, recruited him into this YSL criminal street gang, and led her son down the wrong path. Mr. Eppinger's mother is mentally ill. She's never met Jeff Williams, and her son never said that. That is the type of information you are being given today to rely upon. Ask the state for the proof. There's no problem. You would ask me for the proof, and I'd say, here it is. Your Honor, this conversation that Ms. Love wants to have about the legislature made it different for leaders, she does not cite any provision of law, because it doesn't exist.
It's not really relevant for my bond determination at this point in time in terms of, I mean, still, I have to look at the Iowa factors, and that's my principal guiding foundation.
But aren't you concerned at some point, Your Honor, that you're being told misrepresentations? At some point, do you just think...
If that's the case, then there are other remedies for this court to undertake and other bodies that this court can refer those matters to. I have to take your proffers that you tell me as counsel when we all go through a very lengthy licensure to include a professional ethics MPRE examination given in tandem with our licensure as lawyers. So I think most people take that pretty seriously, because to lie to the tribunal is pretty serious. So if I find that out later on, I'll make the appropriate decision.
And Mr. Williams will still be potentially rotting in jail. The point, the rubber has met the road, Your Honor. I'm telling the court, I'm imploring the court to, if you're relying on that proffer, please ask to see the evidence. Going back, every other term used here is in the indictment. Those are the allegations. The state wants to turn it upside down and say, well, just presume that this happened. Presume now a search that was illegal. Let's presume that as well. The failure to appear, what they didn't tell you was there was no notice given. It was a speeding ticket that got dismissed. That's the failure to appear. Your Honor, you are being given information that is not appropriate. I'm telling the court that Mr. Williams, I would not come before the court. It's the third time. Mr. Williams can have a bond with whatever conditions the court needs. It will just be the right thing to do under law, under Ayala, which is AYALA. I'll answer any of the other questions, but the tour bus, Mr. Williams was, Mr. Love rather put Mr. Williams in that. Mr. Williams was out of state. He was not charged in Cobb County, and there's a memo from the Cobb County District Attorney. He's now a Superior Court judge, the Honorable then District Attorney Reynolds, saying there is not enough evidence to charge Mr. Williams in any crime involving the tour bus shooting that involved the gentleman who performed under the name Little Wayne. That's what you're being told, though, today, that somehow Mr. Williams was involved. And I'm telling you different.
All right, sir. Thank you.
Can't do that. He's a member together. You say you turn the house and show you both of these cases going on right now. Turn the house. He's the night. Yes, it's very good to get the other name. And these two men will be delivered, set free, and come up along to the court of judgment and be witnesses as Paul was to them. In the name of the authority of Jesus and Jesus of God, minister spirits, go forth, touch all parties in both cases. To the glory of God the Father. In Jesus' name.
Versus the state, or pursuant to Iowa versus the state decision by the Supreme Court of Georgia and its progeny going forward, decided February the 5th of 1993, cited at 262 Georgia 704. It's still our seminal case in Georgia in regards to the nature of bond. Of course, a trial court may release a person on bail if the court finds a person 1, poses no significant risk of flight from the jurisdiction of the court or failing to appear in court when required. 2, poses no significant threat or danger to any person, to the community, or property in the community. 3, poses no significant risk of committing any felony pending trial. And 4, poses no significant risk of intimidating witnesses or otherwise obstruction the administration of justice. And that's OCGA 17-6-1 Echo. It requires the trial court to explain its reasons for the grant and denial of bond to assist in appellate review. That's Lane at 247 Georgia 389. That granting or denial of bail will not be set aside unless there's a manifest and flagrant abuse of discretion. And that's a very old case, Jernigan versus the state, 118 Georgia 307 pinpoint 308 1903. IELA requires, and we all know this, and this has been stated at earlier hearings, that the defendant has the burden of coming forward initially with evidence to show that he or she poses, no significant risk of fleeing, threatening the community, committing another crime, or intimidating a witness. This burden of production means that the person charged with murder must present evidence of the bond hearing on the factors that indicate roots in the community, which Mr. Williams has done on prior occasions. These factors include the defendant's length and character of the residence in the community, employment status and history, past history of responding to legal process, and prior criminal record. Court cites Lane 247 Georgia at 388. Once the defendant meets the burden of production, the estate may present evidence to rebut it, and then the court goes on to say that this is proper to place the burden of production on the defendant. So at that point in time, once that occurs, to protect the presumption of innocence, IELA goes on to say the state has the burden of persuasion in convincing the superior court that the defendant is not entitled to pretrial release. This requirement means the state has the burden of proving by preponderance of the evidence that the trial court should deny bail either to secure the defendant's appearance in court or to protect the community. Depending on the quality of the defendant's evidence, the state may not need to present any evidence to carry its burden of persuasion. So I have determined in this case that Mr. Williams has in fact met the preliminary standards to show that he has ties to the community and roots in the community. And I find that his employment status and history are sufficient. The thing that still troubles the court and has been presented to the state by the state in this particular continued proffer is that one of the factors I'm supposed to consider or decide is whether or not Mr. Williams poses significant risk of intimidation or threatening of witnesses in particular. The state's proffer of recent conversations and interviews with witnesses in this case, attributing conduct to Mr. Williams, asking for permission to harm others. The court finds that would make him and pose a significant risk to the community. For that reason, I'm going to continue to deny bond at this time. That's my ruling. Okay. All right, Mr. Weinstein.
Your Honor, as customary by rule, could we take a brief comfort break at this time?
Yes, we can, sir. We'll be in recess. Mr. Steele, just so you may release yourself at any point in time to Judge Ingram, okay?
Thank you.
All right, thank you, sir. We'll be in recess 10 minutes.
of his testimony was captured on videotape, and the jury would be able to see it. And so we would suggest that since we're in a situation whereby the testimony has been captured on video, that the best practice in this instance would be that any testimony that is asked back for not be read back because it would be devoid of its context, but be shown. With respect to Mr. Kelly.
Now we're on back on YW Melling's case.
I would also expedite matters because I'm sure it would be a lot quicker to obtain video footage than it would be to have it typed up. My other point would be this. The request for the testimony of Mr. Glass and Kelly both came in the same question. And subsequent to that, we received a note that indicates that there may be factions that are beginning to calcify. We can only speculate as to what the jury is thinking and saying. But I think it's unequivocal that the substance of Mr. Glass's testimony favored the state. It is also unequivocal that Mr. Kelly made some concessions that essentially his analysis had defects and he really couldn't draw the conclusions that he was attempting to draw. So one can surmise that maybe that might be more favorable to the defense. If we have a jury that's now divided into factions and one side is sending for information that might support their argument, another side is sending for information that might support their argument,
then that's
it would be unfair
to give in.
Allow one side of that faction to get their ammunition and wait another 24 hours before the other side is able to meet that argument with whatever they're trying to fashion or whatever that testimony they're using as a component of their position. So we think it would be prejudicial because we got both requests in the same questionnaire or same question asking for the testimony of both people. And until both is available, first of all, we'd like to be shown back as opposed to be read back. And secondly, we think that it should be done at the same time so that both sides, assuming they're proposed for different sides, are equipped with the ammunition they need when they go back and the deliberations continue. We think it would be extremely prejudicial if Mr. Glass's testimony were to be read today and we tell them, wait until tomorrow before we get your papers.
Thank you, Steve.
Right.
Yeah, that's a 30 seconds in the rules would conform with the readout of current state suggesting that safety of rules of criminal procedure.
So objecting to having some type of single client, more client video this and have that played back to you.
Yes.
Anything else, Council?
Yeah, well, once we can ascertain that it's complete, then clearly it's the best evidence. There might be rules which do not contemplate the existence of video, but now that we know we have it, the court as the gatekeeper knows that it will not be an inaccurate reflection of what has occurred. As a matter of fact, it will be the best evidence of what occurred. Therefore, to use a procedural deficiency as a basis for objection, I think is an attempt to obfuscate what would be the best evidence and the truth. And I don't think the state took a position with respect to whether or not it should be read at the same time, but we would maintain that it would be prejudicial to Mr. Evans. And I know we're reading tea leaves, but because we don't know what's going on, it's all the more important that we give the jury what they asked for at the same time that they asked for it and not split it up.
Thank you. Well, Council, respectfully, the court order is the person who gives the record of the proceedings. So if you want to read that, that's what we're going to do. That's what we think that's happening. The case of live stream, that's not in evidence. The court order will be that. That's what we just provide for. That's what we will do. Regarding Mr. Glass. would